Can you see oh, okay. Can you see yourself on the screen?
I see you and I see me too now. Here
Oh,
we
there
go.
you are. Yep, you got it.
Can you guys see me at all?
We can see you.
Oh, okay. All right. Well, not that that's necessarily any kind of an improvement, because I'm among the many who've lost my razor blade and I'm not sure I can even find my barber anymore. Not that that makes a whole lot of difference in my case. But in any event, if everybody can hear me, once again, my apology for being late. You'll probably get some amusement out of the fact that I've been attempting to connect up with Laura and with the bar for about the last 10 minutes. So it only took me 10 minutes to activate this computer. I'm delighted to be with you, Laura, and I want to just say to you, as our president of the Nashville Bar Association, how deeply grateful I am that you and the other folks at the bar made the conscious decision to employ these kinds of town hall meetings with the various judges across the 20th Judicial District. And so, from my perspective, it's probably good that I waited till the end of April, because so many things have occurred over the course of the month, actually month and a half now, that have affected or had some impact on practicing law in the various courts, that it gives me a chance to kind of piggyback in on what a lot of other very smart people have done in their courtrooms. And with the assistance, and I'm sorry to say, I don't believe that either Scott Pilkington, our special master, who's also my staff counsel, or Elizabeth Johnson, who's my probate master, I don't believe that either of them are going to be joining us today. So unfortunately, they won't be here to help correct me if I say something that's in error. But I want to tell you that over the course of the last month and a half, for those of you who do practice in probate with any degree of frequency, you're probably aware that we have adopted and signed a number of orders. I wanted to kind of go over some of those today with you. And I wanted to tell you that probably if you leave here today with nothing more than the first point of interest that I'm going to bring up, if you just get that first point, maybe it'll be worth your while. We have adopted in the clerk's website, which you can get if you'll go to the Ricky Rooker's Circuit Court Clerk website under the broad heading of www.nashville.gov, and go into Ricky's website, which covers circuit and covers probate as well. If you go to Circuit Clerk and then go to the subtitled site for probate, you're going to find a plethora of information that was adopted with the assistance of both Scott and Elizabeth by court order. And I thought I would go over some of that with you today. Also, because it is a video chat and you're the hostess, Laura, I certainly will entertain questions, and you don't have to wait till the end to pose those to me. You can throw them at me whenever you want. And as I like to tell everybody, I may not know the answer, but I can certainly act like I know the answer and try to provide you with some information. But if you look at that website, and some of you can do that at your home or at your office, if you're like me, when I get outside of my normal environment, which is the chambers in court, and get on my home computer, I'm a little bit lost. But with the assistance of the IT folks, I'm able to now at least get information from the courthouse computer without going to court, like Case Link and so forth. And if you take a look at the Circuit Court Clerk's website at probate with me today, you're going to find, among other things, that we've adopted, first and foremost, each of the Supreme Court orders that have been issued by the Supreme Court of Tennessee over the last several weeks. And we make reference to the Supreme Court order as an embodied order or a reference to that order in most of the orders that I'm signing. Uh, and especially in light of the fact that we do not have in-person court hearings except in very extraordinary circumstances. Now, one of the things I want to refer you to as well is the governor's executive order number 30. Yesterday, I had the opportunity to speak with presiding Judge Joe Binkley at some length about both that order and the Supreme Court's order. And as judges and lawyers are wont to do, you know, we pick over everything that we see, and I want to encourage each of you to do the same thing. Take a look at Executive Order 30 from Governor Lee. Take a look at Executive Order 31, which looks like an order that just changed his treatment of dentists and healthcare providers in the dental arena. But also take a look at their television conferences from the governor and from the president, respectively, because sometimes what you hear people say and what you see in their orders are not exactly the same thing. And we've noted that the executive order from the governor, which basically reminds us that under an emergency circumstance, he kind of overrides everything, that there may be just some slight gray areas that we're going to have to contend with. So once again, if you read that order, if you read the Supreme Court's most recent order from April 24th, and they may have another one coming out that I haven't seen since the 24th, and then look at those orders that I have signed, then I think you're going to be in pretty good stead when you file petitions or file motions that are of a routine nature at least. You're also going to find that one of the orders that I signed, and I printed out a copy of it for myself today and went back and read it, that among those is an order that we did back on April I believe on the 17th, and it's one where I suspended and continued the probate master Elizabeth Johnson's dockets relative to accounting hearings and relative to show cause hearings, fee exceptions or fee disputes, and exceptions to inventories, accountings, and property management plans that might have otherwise or what would have otherwise been set on her docket. Part of the reason I'm doing that, as many of you know, is that Elizabeth is expecting her second baby, and her baby's due in late May. So you know, we're not going to let her come into the courthouse for sure. And we have basically, however, continued to send all accountings to her and inventories for her to review. And those that don't have anything wrong with them, and those that don't have either an objection by an heir at law or a will beneficiary or some other interested party, such as a creditor, those that don't have objections and to which she might not have an objection will still be approved by her, because she tells me that that baby coming or not, she's just going to still look at those items. However, that order also says that if we have to set a show cause order or show cause hearing on an accounting and inventory, or set an evidentiary hearing on a fee dispute or an exception to an accounting during these distressing times, and I say that for certainly the month of May, and then certainly as we go into the first part of June and pending further orders of the court, then those would either have to be set by me or they would have to be delayed until August. Now, the good news is, as you probably know, Laura, we don't usually have a sense of urgency on show causes for accountings, inventories, property management plans, because oftentimes those are matters that can be corrected or cured by the fiduciary who just either screwed up and didn't get court approval on an expense that they made, or maybe they just made a math error. Others, however, where a fiduciary's done something, an act of malfeasance, or perhaps done something egregious, like taking all the money and running off to a casino somewhere. Now those, I guess, Randy Kennedy's going to have to try. So those we would still be setting, but read that order from April the 17th. It's on the website. Likewise, if you'll take a look, in order to streamline matters, all of our cases now are being examined, and not that they weren't already being examined for the purposes of preparing a bench brief and giving me a heads up by Scott Pilkington, but he's now looking at those with a view toward exercising his special master power, which is also incorporated by order, that allows him to go ahead and sign off just as he did on his rocket docket that he used to do on Thursdays. Even though we've suspended in-person hearings, what we're now doing with those is he looks at those, he examines those, and if there's not a question of law, or if the matter is not contested, or if he does not determine that it contains matters that simply cannot be approved, then he'll go ahead and sign the order. Your order will be scanned and entered by the clerk's office, and you'll be able to get a copy of it without ever having to step into court. Now, keep in mind, this is being adopted so that the folks that you and I oftentimes see, elderly widows or elderly widowers, disabled adults who are under conservatorships, so that they don't have to be exposed to a bunch of folks in a courtroom. Now, that doesn't mean we're going to keep doing this forever, but for now, when you file your standard traditional petitions to probate wills, petitions even to establish a conservatorship or a guardianship over property, or things of that nature, name changes, small estate affidavits, all of them will be examined by Scott initially. Now, it's been our experience that on some of those cases, I'm not lucky enough for Scott to be able to just sign them and send them to the courthouse or to e-file them with the courthouse. Some of them are contested, and some of them are matters that need to be dealt with by me in my capacity as probate judge. We have thus far, much to my pleasant surprise, been able to either continue those cases to a date certain in June, when we hope to actually be back in the courthouse, or we have coordinated the scheduling of doing a video like we're doing today. Now, the real irony of that is the least competent person in the room, not the room, but in our circular universe of this video chat is probably the judge, because as you've noticed from this afternoon, or now it's afternoon, I was the last one to get on the video. So we may run into some glitches along the way, Laura, but we're confident that with the assistance of our IT people, Mark Como, who's down in the clerk's who works for Tim Townsend, our trial court administrator, with him and with other folks like Scott helping me, that we'll be able to do video chats that will also involve the taking of testimony, the hearing of witnesses. Now, we're a little unsure at this point as to how to handle that, however, because if, for example, you have, and many of you on this chat have done this, if you have a family full of witnesses in a case that involves a conservatorship for grandmother, I'm still kind of inclined to enforce that 10-person rule. And so I'm not going to have them all in a courtroom if there's, 20 extended family members and 3 or 4 neighbors and a couple of other folks and 4 lawyers, which is sometimes the case. I'm probably going to have to do that by video, and I'm still a little unsure as to what I'm going to do with the witnesses. Am I going to have, if Laura files let's say, Laura, you file a petition to appoint grandmother Smith to be the conservator, and let's say Ralph DeMarco, who I think's on our chat today, I think I saw Ralph's name. If Ralph represents one of the other family members who objects to your client being appointed, well, you guys know what a haymaker that can become. And so in those kind of cases, it seems to me that we're going to have to adopt, at least on the short term, a plan where your party is sitting in your office, Ralph's client is sitting in his office. Those witnesses that you intend to call are going to be probably in your office, and Ralph's going to have his witnesses. And that's going to bring up some other issues that we're really not sure about For example, how does one sequester witnesses if one of you calls for the rule? I'm not sure. I don't have an answer to that just yet. I think we're going to kind of be on that old Scouts honor kind of thing, aren't we? I think we're going to be saying, well, Miss Baker, you've got 3 witnesses, and Mr. DeMarco, you've got 4. I would ask that all of them be placed in your lobby until each one of them is called as a witness. So we'll have to kind of play that by ear. But I can say with some degree of confidence that so far over the course of this month and almost month and a half, I guess, that we've been operating this way, that virtually every case that has been uncontested has resulted in an order being signed by me or by Scott in his capacity or by Elizabeth in her capacity as probate master. And those matters have been entered of record. And among those, of course, would be orders approving fees, orders to close estates, orders to close conservatorships. One of the things I have not done, I noticed Amy Bryan has joined us, and Amy, of course, is director of the Office of Conservatorship Management. What we've had to do in cases where, for example, where Amy may have done a report and found that a conservator has been wanting in complying with all of his or her duties and responsibilities. Most of those cases, I believe, and Amy could correct me if I'm wrong, I think on most of those cases, we've been able to resolve the controversies by phone call, or if the case was one where we really believed we were going to have to remove a fiduciary for improper conduct, those cases have been specially set for a future date. So in any event, those are kind of my initial thoughts. I will tell you that I know that, and if you don't already know this, perhaps one of the other judges who you've had a video chat has brought this up. The Supreme Court of Tennessee has asked that all of the trial courts and really all the courts across the state adopt, if we can, such uniform procedures as will be acceptable to the courts for use by the members of the bar and by pro se litigants as well. And one of the things that I think we've determined in the 20th Judicial District is that because of the unique nature of probate court and the unique nature of our 2 domestic courts, that the 3 of us are probably not going to be able to adopt, at least on bench trials, which is what all 3 of us generally do, the same hard and fast rules, perhaps, that First Circuit, Second Circuit, Sixth Circuit, and Eighth Circuit are going to do, and Fifth Circuit. They are obviously, from a civil standpoint, far more likely to try a jury trial than Randy Kennedy is. I will probably try, 2 or 3 a year at most. Likewise, our criminal courts are going to be adopting, as you know, from having chatted with Angie, Blackshear Dalton, and other criminal court judges, are adopting a little bit different approach as well. So I behoove you, or I want to encourage you to take a look at anything that comes in. For example, I know our colleagues up in Montgomery County, down in Robertson County, in Rutherford, and in Williamson, I know they are all adopting unique amendments to their current local rules on in-court conduct. But I will tell you that I'm sure that one of the things we're going to be having to do, even when we come back, because of the social distancing rules, I really believe we're going to be limiting the number of people we allow to come into the courtroom. So with that, as somebody once told me, in fact, my much better half, I'm at the house today, and my better half reminded me that occasionally I should take a breath. So I'm going to do that.
Well, thank you, Judge Kennedy. I appreciate you being with us today as members of the National Bar Association. And I'm thinking my microphone is breaking up just a little bit here. See if I can remedy that situation.
Well, I can hear you pretty good. Are we losing a mic?
No, I think it must be just that it sounds kind of jarbled, but let me start over again. On behalf of the Nashville Bar Association, thank you for being with us today, Judge Kennedy, and thank you for that thorough overview of how matters have changed in Seventh Circuit Court since this pandemic hit us and became our everyday new reality. I wanted to ask you a few follow-up questions, and I'll incorporate a question that we've already gotten in from one of our audience members. The question concerns contested motions that are an emergency in nature. Is there a way to have a motion like that heard prior to in-person court proceedings being resumed?
There is, and as a matter of fact, if you take a look at the Supreme Court order, among the things that were exempted from the moratorium or the quarantine on in-person court proceedings were things like requests for extraordinary relief that were of a contested nature. You know, it's one thing to come down and ask me for a restraining order to restrain and enjoin somebody from doing some particular matter. But if you've got a contested matter, we can still do either a video hearing, as we talked about a moment ago, or if the circumstances demand it, we can do it in the courtroom. Now, I'm going to probably defer as far as I can and for as long as I can from exposing citizens to a requirement of appearing inside court. But certainly we can do that. And what I've asked folks to do when they file their petitions or file their motions, if they know they're going to be contested, if they will contact Ms. Lammers. Now I know we can do a conference call with no problem. She's done that for me now probably a half dozen times since the moratorium or the quarantine began and since the Supremes entered their order. I have yet to conduct an evidentiary video hearing, however. So once again, like I said earlier with trials, it may be a rough sledding to get it done, but absolutely, if we have one and you're convinced that it requires testimony or it's contested and you believe the two lawyers need to engage in oral argument, then I'm certainly not going to deny them that opportunity. But I would like to say this. I would like to see their pleadings first, because sometimes, being an old lawyer that used to practice law, I used to think all my cases were emergencies and they certainly deserve priority. But sometimes when you read through your pleadings and you read through the relief that you're requesting, occasionally, and without the necessity of having to put on proof, the attorneys on both sides can reach a resolution with a pre-hearing conference with the court. And I have done that on a couple of cases already, where the parties respective counsel, believed the matter was an emergency, but after we shared with one another what their issues were, we were able to come to an agreed order. So I'm not saying everything's going to end in an agreed order or a kumbaya, but we'll certainly not discourage that.
Judge Kennedy, I don't know if you've had an opportunity to hold any kind of in-person hearing since the Supreme Court suspension on in-person proceedings went down. But if you have, or anticipating that you may have an emergency that requires an in-person hearing, what sorts of social distancing measures have you put in place or do you intend to put in place?
My intention is that in light of this, we've got this thing about recreational matters. I think when I read the order, I think it's paragraph, the governor's executive order talks about social gatherings at paragraph 2 on page 3. He says that social gatherings of 10 or more remain prohibited. Well, I don't see a whole lot of difference between social gatherings and a courtroom full of people sitting around in the gallery chatting just before we open court. I have spoken with the trial court administrator and my staff as well about limiting the number of people that will be allowed to be in a courtroom, and by designating that they're going to sit at least 6 feet apart. Now, that may be a little awkward to start with, and it may delay our dockets, but I anticipate that when we actually get back into the courtroom, that we will be setting our hearings up so that, if we can anticipate this properly, that if you have a hearing like we talked about a while ago, where you, Laura, have 4 witnesses and Ralph has 3 or vice versa. Well, already we've got 10. We've got you 2 and 7 more. That's 9 people. Take me, that's 10. I've got a docket clerk, at least one of 2 court officers in the courtroom as well. So we're already over the 10. I anticipate that we probably will extend this beyond the 10 if it doesn't violate the Supreme Court's order or one that they might have forthcoming, and probably go up to as high as 15 or 20 people in the room, because I have a big courtroom. But even if we do, I'm going to enforce the 6 feet apart, and I'm struggling with whether or not to enforce masks. My wife Debbie, who many of you know, and I went to Kroger the other day. She and I were one of maybe a third of the people in the Kroger store that had on our masks. When I went the other day to get gas for my car and pulled up to the gas station, I was the only person that apparently was concerned enough to have a mask on. Now, so far, nobody in my family's gotten coronavirus. I don't want anybody in your family to get coronavirus. So, quite frankly, I'm inclined to require that attorneys and litigants and witnesses wear masks. Now, the downside of that, and I'm very aware of it, is how does one determine the demeanor of a witness with a mask? And am I depriving somebody of their right of confrontation? I think all of that kind of remains to be seen. Thank goodness most of our hearings are not contested. So I'm probably going to have a lot of social distancing in. I'm also going to recommend to Mr. Rooker that he consider putting up a plexiglass for my docket clerk, who many of you know, Penny Hubble, and for her substitutes, Deanna Alexander and others, because there's so many of you, when you're in our court, will approach her with an order that's been revised on that very day, or a proposed document, or an exhibit. And while I don't mind you handing me paperwork, and I'm going to have my little gloves and my little mask, I don't want to expose her to that. Now, I'm not going to put up plexiglass for the witness chair, nor am I going to require them at this point of jurors, although I can tell you there's a lot of discussion among those judges who try jury trials about perhaps dealing with that. And the good news for me is my jury trials have all been continued till August at the earliest.
One question that has come up in several of these town halls is, once we get to the point where in-court proceedings can resume, if there is an attorney or a litigant, and I imagine in your courtroom you see this a lot, that falls into a high-risk category because of age or health concerns, will there be some accommodation where lawyers and litigants are not required to appear in person if it would put them at a greater risk?
I think that's a great question, and I believe we do have an obligation to accommodate those folks. What we've got to be very careful of is that, and we lose sight of it in our zeal to dispense or administer justice and to have a fair and impartial hearing. We sometimes forget that in order to achieve fairness and impartiality and to achieve justice, that you have to make special accommodations for both counsel and for litigants. In our case, Laura, it's probably more likely to occur than maybe in any other court because of the number of elderly and infirmed individuals that we have, and that also includes members of the bar. You're absolutely right. We've got them, and lawyers don't. As somebody once said, lawyers never retire; they just lose their appeal. And I've got lawyers who are coming in now that are still in their mid-80s, that are still practicing, and maybe we tease them a little bit and say, "Gosh, isn't it time for you to retire?" But the truth of the matter is, they still have a great deal to offer for their clients, and I don't want any of them to get sick or to die because we force them into some herd of people. So yes, absolutely, we'll make accommodations.
You've mentioned in the course of your comments that several matters have been continued in your court, trials and contested motions and things that maybe aren't an emergency or that can wait. What sort of backlog do you anticipate once we have the all clear for in-court proceedings? And how do you have an idea of what it's going to look like to work through that backlog?
Well, I think the first thing you want to look at is what's the volume that we already handle. In a normal situation, we're handling approximately 2,300 cases a year. Part of my backlog has been alleviated already by the fact that Judge Amanda McClendon in Second Circuit Court has taken and accepted a transfer from me by interchange of all of the initial hearings on emergency conservatorships and on any expedited limited healthcare fiduciary cases, 98% of which are generated by hospitals. Now, she's busy. I can tell you she's busy as we speak, handling those kinds of hearings, which have 5-day follow-up hearings. Fortunately for me, while I'm there to assist her on those are now off of my docket. So consequently, my volume may actually have gone down a bit prior to the onset of the coronavirus. When we come back, however, I fully anticipate that there will be a backlog. I think the backlog is going to be fortunately accommodated, because what we will do once we figure out that we have had a 14-day decline, by the way, which we've not had yet, I want to emphasize. Once we know that we're back in the courtroom and we know we're accommodating or hearing cases in somewhat of a normal way, we're probably going to have to take those contested cases, give them some preference. As I did in the past, my Mondays and Tuesdays are likely going to be contested trial dates. My Wednesdays and Thursdays will continue to have normal or limited normal dockets at 10 o'clock and at 1:30. My Friday will return to being a motion day, but I am sure that my Mondays and Tuesdays will stagger them out, and we will probably say, let's set one at 9, let's set one at 11, let's set one at 1, let's set one at 3, for those that can be done in an hour or two. We don't always know how much time we need, but I would anticipate there'll be certainly a backlog. I'd be a little bit presumptuous if I tried to estimate specifically how many. I don't know at this point.
I'd like to take a brief pause just to remind everybody on the call that if you have a question for Judge Kennedy, if you'll use the chat function, I will be sure that we ask that question of the judge. Judge Kennedy, the Tennessee Supreme Court has encouraged the use of Rule 72 declarations. The governor has put out Executive Order number 26 to facilitate remote notarization and witnessing of documents. How has that practically played out in your court, and is there any guidance or recommendations that you can provide?
Absolutely. I'm glad you brought that up. What we did in Seventh Circuit Court is we actually adopted an order. I think I can reach back. If you look at the clerk's website, we referenced the order, and I think it's the order that we adopted, which I have printed off a copy of for today's program. I signed an order on April 15, 2020, entitled Order Authorizing Inventories and Accountings to be Signed under penalty of perjury until the expiration of the Supreme Court order continuing suspension or of in-person proceedings and extension of deadlines. I would encourage everybody to take a little look at that. It's the NRA COVID-19 pandemic order, as we call it. And among the things that you all are so used to having to get notarized are inventories and accountings. For this purpose, for now, you can get by with saying under penalty of perjury. That'll be fine. Likewise, I have not run into, speaking of the governor's order and the Supreme's order as it relates to notarizing or being a notary to witnesses, or a notary to a testator, or a notary to a verified petition. I have not yet run into a challenge on those documents that have not been notarized. I mean, I guess I've been lucky despite our volume. I would anticipate that down the road, there's going to be some challenges to, for example, in will contest cases, you got to prove your wills anyway in a will contest. So even though they may have been notarized, they may be a self-proving affidavit, the nature of a self-proving affidavit kind of falls by the wayside if it becomes a will contest. But in common form probate, should we have, and I've yet to see one yet, I know they're out there, where you've done a will at a nursing home through the window, what I call the through the window project, or by video, where you've had them sign a document, but you haven't been able to be with them. I think we're going to have to play it by ear. We're going to have to look at what the Supreme Court said and what the governor said, and if it's in compliance with Rule 72 or with the Supreme Court's statements on Rule 72 and the governor's order likewise, and we're going to admit it to probate. We're going to rule that document is valid, but it's going to be a case by case basis, I think.
The Tennessee Supreme Court orders have extended certain deadlines. How has that played out in your courtroom? What deadlines have been affected, and how are you interpreting that?
Well, we interpret the extension to include answers to complaints, statutes of limitations, and of course, as you all know, probate is really a creature of statute in many ways. Probably more so sometimes than some of the other courts, and we've taken a very liberal and broad view of the fact that if the Supreme say we're going to stay the enforcement of statutes of limitations, far be it from the lowly trial judge to not do the same thing. So if you have, for example, an obligation to file, let's say it's an exception to an accounting, which ordinarily would have to be filed within 30 days. That expiration date has been extended indefinitely. Now, the issue that probably is going to come up for a lot of you, however, is what happens when it stops. Now, I'd be very cautious. I don't know that I would necessarily sit on my hands because of the Supreme Court's ruling. For example, if you're ready to file an exception to an accounting, go ahead and do it. If you've got a statute of limitations running and you've got your paperwork prepared and you know you need to go in and file your petition to contest a will, there's nothing wrong, or you need to announce you're doing so. I would still go ahead and file whatever I'm going to file. I wouldn't just assume that they won't put us all back in place pretty soon. Some people are of the opinion that we're going to be back up and running like nothing ever happened before. I'm not of that opinion. I think we're going to have a new normal, and the new normal may result in these statutes of limitations and statutes of repose and deadlines on responses to motions and so forth being extended on into the summer, maybe to the end of the summer. But I certainly wouldn't rest on that. I would be very mindful every time the Supreme Court speaks. I think we all need to take a look at their orders, read them closely, and we need to go in and take a look at every court in which you practice on local rules and on those of us who have the luxury of having a website to see what we do to update our orders.
The most recent Tennessee Supreme Court order allows each judicial district to submit a written plan for resuming some in-court and non-emergency proceedings. You referenced it in your initial comments. Based on what's being put together for our judicial district, do you have an estimate on when we might start having in-person proceedings again? And can you offer us any insight into what that's going to look like? I think you're muted, Judge Kennedy.
I'm unmuted. Okay, sorry. I guess if I read this thing that you're printing up in front of you, I'd know what to do there. Let me back up. For those that didn't hear me a moment ago, as you there are certain courts that are currently conducting in-court proceedings. Among those are Smith and Robinson are doing so on domestic violence cases or orders of protection. Judge McClendon, I know, as well, is doing them. Across the street in the Birch Building, the criminal court judges are having to do some as well. From my perspective, and I think from the non-domestic circuit judges as well, I would not be surprised if sometime in early June that you begin to see a degree of in-court proceedings being accomplished. I'm hopeful that we're going to be able to start back in early June. We had actually scheduled some hearings for mid-May and late May that, as a result of the most recent Supreme Court order, we've had to go back and delay. But even as we speak right now, I'm still scheduling with Kitty and with her assistants and with Scott's assistants some hearings in June. I'm optimistic that we're going to be able to do that. I have not scheduled any jury trials, as I mentioned earlier, until I think August is our first jury trial now. And I know that we're going to revisit this question probably on a weekly basis, if not more frequently.
I have another question from the question is, if a matter is currently set for a status review hearing, is that automatically continued, or do the lawyers need to submit orders to continue those?
If you have a status conference that's been set, let's say in May, and we have not actually continued it ourselves, and you wish to do so by phone, we're going to accommodate you. I mean, I'm going to do those without fail. On the other hand, if because of your own issues involving the pandemic, and I've got a son who's an attorney, as many of you know, and I've even though he can't practice in front of me, I know he has run into these same and similar situations. And if you say to me, and I think he's done this in some courts that he's been in other counties, if you say to me, I can't do this one on May 27th, or I can't do the one you set, Judge, for May the 16th, we need another date. Or you say it to Kitty, you call in and you tell my judicial assistant, we're going to accommodate you. We're going to bump it. We're going to move it if you want us to move it. On the other hand, if you're ready to go and you want to be heard, you feel it's compelling that we have at least a oral argument, consultation, or conference, we'll conduct a hearing by phone or by video. And the good news is I'm going to learn how to use this Zoom, so eventually we'll be able to do that as well. So.
We have another question from an audience member having to do with guardian ad litems, meeting with potential wards, and also with service of process on people who are in institutions like hospitals and nursing homes. What recommendations or what suggestions do you have for accomplishing those things?
I wish I could make a direct reference to an order that I signed earlier this week. I can't think of the name of the case because we've got so many of them, but I signed an order earlier this week that because of a guardian ad litem's difficulties in getting in to see the respondent, and because of the difficulties in getting to interview people inside the establishment, that dealt with service of process and dealt with her conducting her interview, which, as you know, usually includes the guardian ad litem serving the petition. And some of your viewers or listeners or lawyers on the call today probably are very concerned about that. We're going to make this as easy on you in your capacity as guardian ad litem as I can make it without violating the due process rights of the respondent. In that particular order, if I can paraphrase what I signed, what we did is we directed that the executive director of the nursing home make herself available to receive the petition or the pleadings, that she be required to place the pleadings next to or in the room or upon the table next to the respondent patient, and that by video, because all the nursing homes in Nashville are supposed to have this capacity, and that by video, she make the respondent available, even if the nurse or the attending care provider has to hold the phone up to the respondent, so that the guardian ad litem can literally read the pleading to the respondent, which is the act of service, and then to allow her or him, the guardian ad litem, to examine and to inspect all documents that are going to be made available by the nursing home, as well as to be able to interview the care providers, whether they be RNs, nursing assistants, physicians, or whomever may be on call at that facility. Now, we'll see how that works out. That was the first of those that I've had this month where the guardian ad litem ran into that wall. And that wall is there. Believe me, I deal with it every day. My 92-and-a-half-year-old mother is in a memory care unit. And, I visit with her by phone and also by talking to her through a window. It's not an easy thing to do. And I don't envy you all having to do it for our courts, but we're going to get it done. And I think that will cure our due process issue, because the pleading will have been served upon the respondent. And in fact, my order predetermines that upon that having been done, that will be in lieu of the guardian ad litem being required to physically go into the room of the respondent. And quite frankly, since they're quarantined, I don't know of another method by which to do that at this point.
Judge, if you could locate that order or the case name and send it across, we'd be happy to provide a copy of it to everybody who's on this call.
I will do that. In fact, I don't know that I have it with me here at the house. I know we signed it. What I will do this afternoon, I'm going into the courthouse because we've got this thing called the queue. Many of you are familiar with it, where judges can go in and sign a whole bunch of orders without having to personally sign them, which also is an interesting concept. But in addition to that, I've also got 35 orders here at the house with me that I've examined and signed that I've got to take in. I will, with Scott and Kitty's assistance, will retrieve that order. Won't be able to get it to you during the conference call, but if we've got the names of these people and if we can get them out to everybody, that'd be great. I'll be glad to do that.
Thank you very much. I want to take one more pause just to remind everybody on the call. We've got about 10 minutes left. So if you have any questions that haven't been addressed yet, please send them across and I'll ask them. In the meantime, Judge Kennedy, I wanted to ask you if there have been any silver linings in this time of uncertainty for probate court, or anything in particular that you've been grateful for.
Well, as I mentioned to you earlier, I'm certainly grateful for the fact that none of my immediate family has so far been touched by the virus directly. Indirectly, like many of you, I know people who are related to people who have died or have come down with the virus and gotten better. From the court standpoint, one of the best things that's happened to me, and my wife Debbie and my staff will definitely back you up on this if you don't already have this opinion. I'm probably as computer illiterate as any judge that you deal with. I've had the luxury of delegating to everybody else for as long as I can remember on the use of my computer. Until this happened, I did not read my own emails from the house. I didn't do it. I didn't read them till I went back into the courthouse. Now I also rarely looked at CaseLink directly. I would ask somebody to print something out for me. I needed a hard copy. Well, I've got to say, since I've been sequestered and away from the courthouse more than I've been there, I can actually go into my own emails from the courthouse. I can correspond with people whereas I couldn't before. I certainly can get into CaseLink a little easier now than I did before. Beyond that, I think it probably has required me to go back and read directly and in far more detail pleadings and briefs than I might have done in the past. Beyond that, it's kind of slowed me down a little bit. I'm grateful for that too. My wife's grateful because our yard looks a lot better. I'm doing a lot more chores than I used to could excuse myself by not getting home before 4:30 or 5. When you're here, it's kind of hard to avoid that. So, although I think she's ready to kick me out as we sit here.
We have another question from our audience, a very important one actually about court procedure. The question is, what music have you been listening to help you get through this pandemic?
I'm glad you all brought that up. You know, unlike those of you who are fans of Alice's Restaurant, I don't believe that the music died when Buddy Holly did. I'm pretty sure that the 60s, as I've often said, are the golden years, and the 70s are an outgrowth of the 60s. I can assure you that although I have picked up a lot more bluegrass at the insistence of Scott Pilkington, who's a bluegrass aficionado, this judge is still a rock and roller. I'm still listening to Crosby, Stills, Nash and Young. I'm still hitting on the Beatles and everything from the 60s and the 70s that you might throw my way. So, and I haven't stopped listening. In fact, for those of you that are really bored, let me recommend to you that there's never been a Beatles song that wasn't a good song to listen to, and most of them are uplifting. Now, I'd stay away from Eleanor Rigby because she did die in the church along with her name. So, and nobody.
Now, Judge Calloway sang for us during her town hall, but I won't ask you to do that for us today unless you'd like to.
Well, yeah, I would say that my singing days are. My wife says they're thankfully behind me. In fact, she does not find my singing she doesn't find my singing to be nearly as perfect as I once claimed it was. So I'll spare you guys any music from me today.
Let me ask you another substantive question. Are there any changes that you've made in your procedures in your courtroom because of this pandemic that you are considering keeping for the long term, even after the risk has subsided?
As a matter of fact, there are. We had probably been going in this direction to some degree without really me asking anybody to do it. Some attorneys have found it appropriate to bring their clients with them on that initial hearing on a petition to probate a will. Others will bring them down for, say, a petition to probate a will for muniment of title only, which, as you know, is really not a traditional probate process. Others have, especially those who have an out-of-state fiduciary or an out-of-state petitioner, have oftentimes said, well, I'll just come in with my verified petition. I'll present the petition. I'll present the will. And hopefully Judge Kennedy will sign my order. And if everything's in good shape, we do. I really believe, although I'm never going to, I shouldn't say never, I'm unlikely to deny any litigant an opportunity to come into the courtroom once we get back, because I know litigants want to know what's going on. They want to know how the sausage is made, and I don't blame them for that. But I think if you've got an elderly or an infirmed widow or widower who's asking you to probate his or her estate, if you can discourage them from coming to the courtroom without leaving them in some kind of uncertain, suspicious realm over what you're doing with their husband's will or their wife's will, I would want to encourage all of you to do that, especially if you're sure you got your T's crossed and your I's dotted. Because her trip or his trip to the courthouse, at least now, even after we go back to court, until the virus is over, and by over, I mean over, until we've got a confidence that it's not going to come back, we don't really need to have them come to court. I mean, I love to meet them. I think you all that know me know I love to talk and I love to listen to them, but I don't want to make them come to court. And so I can see both that and small estate cases where you have a lawyer representing the affiant. Those are two areas that I can see not requiring court appearances. Likewise, even in the conservatorship arena, and I will continue to to do most of the traditional conservatorships and some of the emergency conservatorships as well. I don't really believe that it's necessary if you have service of process on the respondent, even if it's a young adult. Let's say you've got a young adult who's turned 18, and as long as you've got them served with process, if they have a disability that causes their immune system to be in jeopardy, why would we put them through the ringer of having to bring their wheelchair or bring them to court just to hear us tell them that we're going to appoint mama and daddy as their conservator? I think we ought to figure out a way to dispense with that if we can. I also ought to mention this. I'm not adverse to letting lawyers do their argument by video. On the other hand, I understand. I'm not so far removed from my own law practice not to know that oftentimes attorneys feel much more comfortable advocating their point of view in front of the judge at the podium where they can make their point more vigorously. And so I'm probably going to I'm probably going to allow that more than I have in the past, a video conferencing on motions. So that's kind of where those are the changes I can see coming in the future.
I think we have time for one last question from our audience. And the question is, post-pandemic, are you considering having a true no response motion docket on Fridays as opposed to just limiting the no response docket to fees?
Yeah, I am. We've really kind of been doing that during the pandemic. Virtually, every one of the fee orders, for example, the motion for fees that have come in. Of course, the dilemma is you have pro se litigants who are heirs at law and will beneficiaries who might show up, and it may very well be that that adopting a no response rule, which we've not done under the local rules yet, is in the offing. I can see that it may be more efficient. It will certainly cut down the number of people who find themselves having to come into our courtroom on a Friday. And so I will certainly consider doing that.
Judge Kennedy, I want to thank you again for taking the time to have this town hall with our members and answer these questions and give us your insight on what we can expect in the future. This has been really helpful.
Well, you're all very welcome, and I just want to say to all of you, I hope you stay safe, wear your mask, be successful in your law practices, and I look forward to seeing all of you. And I'd hug y'all, but they're telling me hugging's out. So with that, this will be just kind of a video hug from me to you. How about that?
Thank you, Judge Kennedy. Thank you, everyone, for participating. We'll now bring the call to a close.